I think we're going to roll right into some introductions here. Janine, would you like to start us off?
I would. Hello, guys. Thanks for joining us today. I'm Janine Lewis, Director of Marketing, Quality Assurance, ADR Transportation, and Sports Marketing. Again, thanks for joining us. You're going to have a fantastic session today. And Tammy, thanks for reminding them that they can pick up the part 1 if they did miss that. It was an exciting one. It also included some training on AI and how that's involved in the trucking industry. So I'm going to kick this over to Kimberly.
Good afternoon, everyone. My name is Kimberly Wagner. I am the managing attorney of the Bradford Barthel Ventura office. I am also a certified workers' compensation specialist, and I did assist Nas with the part 1 presentation. So if you missed it, go ahead and check it out. Over to you, Nas.
All right. Good afternoon, everyone. My name is Nasir Adil. I am the managing attorney of our Oakland office. We primarily cover the San Francisco and Oakland WCAVs, also do some Stockton coverage as well. Thank you for allowing for us to present to you today. Your time is valuable, so we definitely appreciate you taking your lunch hour or late breakfast or early dinner, wherever you may be, hour to join us. Just want to remind everyone, if there is anything that comes up following today's webinar that you have questions on, Kimberly and I are obviously here for you all always. If you have panel questions, doctor questions, TD questions, and you need someone to review anything or bounce anything off of, we're always available for you. So feel free to email us, call our cell phones, hunt us down. We're here for you always. Before I move on, or before I jump into the first half of the presentation, I have a dad bad joke for everyone. My dad bad joke is it's Halloween inspired. It goes like this, and it's for you all. What do you call 2 witches who live together? What do you call 2 witches who live together? Broom mates. Get it? Broom mates? Broom mates? All right. Yeah. All right. Anyway, I'll stick to my daytime. I'll stick to my daytime job. In any case, Tammy, can I jump in, or do you want me to jump back in? Is that okay? All right.
Yep.
So today, everyone, it's going to be primarily my presentation will primarily be dealing with kind of common day dealings, as far as common day everyday dealings that cross over into workers' compensation realm for truckers. And I'll be kind of getting into trucking hazards, driver fatigue, as well as health, including mental health, as well as drug and substance abuse and alcohol issues that are prevalent. First one, trucking hazards. Now, trucking hazards these are common occurrences which can lead to different type of workspace, workplace risk and exposure hazards. Some of these are commonsensical, but these are very important because these are what lead to different types of exposure and injuries for the trucking industry. Drivers, of course, face numerous hazards that includes traffic congestion, road construction, detours, poor road construction, and inclement weather. These are the most common kind of road hazards faced by drivers. We deal with it every day, of course, going to and from work, dropping our kids off, going to school, whatever. But these type of things are, these are factors that actually play a significant role in the increased workplace exposure for different types of injuries, whether they're specific or less cumulative, but definitely more specific in nature. Now, another one is driver fatigue. Again, kind of common sense, but sleepy drivers equate to unwanted motor vehicle accidents and guess what? Ding, 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 exposure. So to combat that and to kind of work with that knowledge to address the problem of driving while tired, Canadian and American experts, they developed what's called the NAFMP. That's the North American Fatigue Management Program, which is an online educational course, different modules for different carrier executives, managers, drivers, etc., to reduce the number of accident-caused fatigue. It's a service that's available to really kind of be a service, indiscreetly or discreetly, to help drivers know that, hey, you're supported. And the whole point isn't just to reduce exposure, but it's also kind of lead some support in the trucking industry where it's definitely warranted. Various types of voluntary courses. Now we have driver fatigue. There's different courses that we're talking about. There's safety culture, manager practices, driver sleep disorder management, driver family education, etc. This is again done these are voluntary courses that are provided. And the whole point is to reduce exposure, know that the drivers are supported, and really it's a win-win-win, which we'll get into. Less driver accidents lead to happier insurance companies, but it also is a public risk reduction as well. Of course, if there's more drivers who are out there following the right applicable laws and getting their sleep and feeling mentally taken care of, then obviously the public wins because there's less accidents on the road. Now moving on to health and mental health, and this is specifically occupational health-induced conditions. In these situations, there are over 3 million truck drivers employed in the commercial transportation and material moving occupations. It is one of the largest occupational groups in the U.S., and workers are often at risk for different types of occupational health-induced conditions. Things that we probably can guess, but of course there's mental health and psychiatric disorders due to stress. Of course, that's a big cause for CT injuries, right? And with low access use of healthcare and limited social support. So the whole purpose of the study is to give drivers, especially male drivers, believe it or not, mental health risks and associated comorbidities. That's what the study was, to explore those causes. Now, the health and the mental health aspect is kind of what you'd expect. Surveyed drivers were actually found to have significant issues affecting their mental health. These are things that you probably expect, like loneliness, depression, chronic sleep disturbances, anxiety, and other emotional problems. Not really huge surprises, right? Truckers are often alone or with very few individuals for long stretches of time. So that's kind of why you can kind of imagine that these are the effects that do happen over long-term exposure. So the whole point is to reduce that and make sure that to help researchers develop interventions to improve the occupational and emotional health of truck drivers long-term. And by intervening and by doing so, it's actually reducing risk and exposure. So there's definitely incentives for everyone involved: insurance companies, employers, public safety, the drivers, everyone. Now, again, health and mental health. This is why it's a win-win-win. Mental health promotion, assessment, and treatment must become a priority to improve the overall trucking environment for truckers, the transportation industry, and safety on highways. Why is it a win for drivers? Of course, they're taken care of and they're healthy and they're safe. It's a win for insurance companies and those of us on the line because we have reduced risk. Of course, it doesn't reduce risk entirely. We still have truckers driving for long periods of time on crowded freeways, but it does reduce the risk overall. The employers win, of course, because they have reduced premiums that they're paying due to reduced accidents, hopefully. And back to what I was saying before, the public wins because it's public safety, reduced accidents on the road. So this is one of the few scenarios in life where it really is across the board win, 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 win. Right? Huge shocker here. Huge shocker, everyone. No drugs allowed. I know it's a huge shocker for everyone, but common sense again for this one. But it seems like it's commonsensical, but historically this has actually been a big area of concern for decades now with truckers. In order to keep awake, drivers do revert to taking drugs. And there's different types of drugs, right? Obviously, we're all adults on the phone, but in the past, there's actually been amphetamines that have been common in the trucking industry to keep drivers awake, which no surprise that led to accidents and motor vehicle accidents along the way. So the different restrictions that are in effect are not only for illegal substances, but also for different types of legal substances like alcohol, prescribed drugs. And the whole point is to make sure the risk is reduced for everyone involved. Now, there's actually a Transportation Employee Testing Act of 1991, which did come to effect about over 3 decades ago. And that's for a requirement of drug and alcohol testing of different safe transportation employees in trucking and other transportation industries. It's the acronym is DOT, which publishes rules on who must conduct alcohol and drug tests, how to conduct the test, and what procedures to use when testing. As you may know, the reason why a lot of these actions were taken into effect were because there was a rise of different accidents at the time. So the Omnibus Transportation Employee Testing Act was kind of a wake-up call to the whole industry to kind of make sure that everyone's on the same page, make sure there's guidelines in effect to really take care of the trucking industry as a whole. I mean, anytime you see a big effect as far as increased motor vehicle accidents, drug use, it's time to wake up. And I'm happy to see that the last 3 decades, this has had a considerable impact on the trucking industry. Now, back to the common sense. This is a recent study that showed that 30% of truck drivers admitted to taking amphetamines on the job. 20% use marijuana, 3% use cocaine. Of course, I'm sure that these numbers are probably higher just because a lot of employees probably withheld some of that information. But this kind of just goes to show that there are safety concerns that are real, and these numbers are probably higher. But again, whenever drivers feel supported and they feel like they are taken care of, then we all win, including the workers' compensation realm. Note, I was actually kind of surprised by this, but it actually does make a lot of sense. As far as the alcohol level, which drivers have to abide by versus you and I, the normal civilians on the roadway, the Federal Highway Transportation Authority established 0.04 as the blood alcohol level for the BAC. So if you have at or above that as a commercial driver, it's deemed to be driving under the influence. Those of us in California, I believe it is 0.08. Don't quote me on that, but I believe it is 0.08. And it's also 0.10 for non-commercial drivers, depending on the state. But the fact that 0.04 for an adult who weighs, let's say you weigh like 160 pounds, that's like 1 or 2 drinks in, you pretty much reached the 0.04 level. So of course, anytime you're handling, huge 15, 16 wheelers, 12 wheelers that weigh multiple tons, you definitely want to have drivers that are sober, awake, healthy, conscious, because that's common sense, right? To be healthy and safe on the roads. Now, this is kind of deterrence here. Deterrence is key. The regulations note that a driver who has been convicted of driving while under the influence of a controlled substance or alcohol will lose their driving privilege for 3 years. So for those civilians who have had a DUI, it does have a different effect for civilians. I believe it's 1 year or so. You either have to be under supervision of different courts as far as your driving, your distances, where you can go. But understandably here, if you are found to have been convicted of driving under the influence for a truck driver, you lose your livelihood and your privilege for 3 years. So that's a major deterrent as far as losing your livelihood for that long. It's understandably in effect for a reason. So again, before I transition on to Ms. Wagner, I want to remind everyone, please let us know if you have any questions afterwards, but let me go ahead and transition on to Ms. Wagner.
Thank you, Nasir. All right, so conversely with the DOT regulations, the codified federal regulations do not specifically impose consequences for employees who fail a pre-employment drug test, though, as Nasir mentioned, the result for drivers can, of course, be loss of employment offer, a requirement to go through return to work programs, and applicable criminal penalties such as loss of driving privileges for 3 years. Employers must also obtain information from prior employers for the last 2 years with respect to positive results from drug tests or refusal to test. Code of the Federal Regulations Section 382.301 does require that a driver be tested for controlled substances unless the employee meets a list of exceptions. And those exceptions include participation in a controlled drug program within the past 30 days, and therefore drug testing within the past 6 months, or participation in random drug testing for 12 months, and no prior employer has records of a violation of the controlled substances rule for the past 12 months. Drug testing is looking for marijuana, THC, cocaine, amphetamines, methamphetamines, MDMA, opiates, codeine, heroin, morphine, hydrocodone, oxycodone, hydromorphone, and oxymorphone, as well as PCP. So there's a whole slew of drugs that truck drivers hopefully are not doing, but that are being looked for by these drug tests. There's also discretionary alcohol testing that can be conducted, but the regulations are very specific that the testing must be administered equally to all covered employees who perform safety-sensitive functions. So obviously the goal there is to make sure that you're not singling out certain types of employees, or especially not specific employees, to do routine alcohol testing on those particular people. If the alcohol test is going to be performed pre-employment, it must be done after the offer is made, but that offer can be contingent on the results of the alcohol test. And as Nasir mentioned, the threshold is 0.04 BAC. So for reference, percentage of blood alcohol content is measured by gram of alcohol per 100 milliliters of blood. So a BAC of 0.1 equates to 1/10 of a gram of alcohol per 100 milliliters of blood. As Nasir mentioned, on average, 2 standard drinks will generally produce a blood alcohol content of 0.04 in a 200-pound man, at which point reaction times may be slow and fine motor skills can be affected to the extent that it can impact driving. So it makes sense why that's the threshold, definitely a threshold we want to make sure the drivers are staying under. And of course, it goes without saying, for anyone not of age, many states, including California, have a zero tolerance law. So if you are under 21, you may not test with any alcohol in your system. Okay, next slide. So we know that the Department of Transportation does not impose the actual type of penalties on the drivers who test positive for drugs, but it does require employers to test drivers before they can be allowed to operate a commercial vehicle. That was updated in 2023. Previously, it was that you could operate a commercial vehicle for up to 14 days while you were pending records from other employers, but at this point, they do require that negative test before you can operate a commercial vehicle. We talked during part 1 of the presentation about the fact that there can be concurrent employment situations for truck drivers, specifically with respect to if you have a route going to one location where you're dropping off a load, you may contract with somebody in that location to bring a load back so that you're not losing income from the drive to and from, or you're getting double paid potentially to drive to and from a particular location. So this is where the exception that I just mentioned would come in. So if the person has been subject to random drug testing for the last 12 months, they would not have to undergo repeat specific testing for the new or concurrent employer, but the new employer would have to obtain records from the prior employers or concurrent employers in order to grant the exception to the new employee. There has been a push in the industry amongst the trucking blogs to require hair follicle testing in addition to or in lieu of urinalysis. But that was rejected in 2015 as well as in early 2023. Hair follicle tests are supposedly more comprehensive and can detect substances up to 90 days after they are used. And it can also be more difficult to tamper with the sample when it's being given. There are also new federal regulations which require an alcohol breath test and a saliva test once per year. And in addition to pre-employment tests, I just wanted to talk a little bit about post-crash tests, which may also be required by the Code of Federal Regulations. Specifically, a post-crash test is required where there is a human fatality, whether a citation is issued to the driver or not. Testing is also required if there is bodily injury, which must be treated away from the scene of the accident. So somebody who has to be transported by ambulance or otherwise treated outside of the accident, or if there is disabling damage to the vehicle requiring a tow. But in those cases, the testing must only be done if a citation is issued to the driver in either situation. I do think that an employer could reasonably have a policy as long as it is uniformly enforced, where they can require drivers who are engaged in these types of accidents to undergo testing. But again, this is a policy that would have to be applied to everyone. Commercial drivers must also be randomly tested throughout the year, and drivers who are self-employed and do not lease their vehicles may be randomly tested as part of a selection pool. So we did discuss that a little bit as well in part 1 of this webinar, where a lot of truck drivers are in fact self-employed. There's the whole debate currently with the independent contractor aspect with Prop 22 and the constitutionality, which is still pending at this point. But those people who are self-employed don't get to escape the drug testing just because they are self-employed. they do still have to undergo that randomly as part of a regulated pool. A driver may also be immediately tested upon reasonable suspicion that they are under the influence. So it is important to make sure that supervisors are trained to detect any signs of impairment. It is also important to ensure that your supervisors are specifically documenting the signs of impairment that they observe, i.e. why they are actually doing the drug or the alcohol screening, and why they think the person is impaired, not just I had a feeling that they were under the influence or something like that. You want to make sure that they are fairly and objectively assessing the drivers so that you don't end up with a civil claim, maybe for harassment or something like that from the employer or from the driver. A test is required as well if a driver tests positive or refuses a test before that person can be returned to work. So in other words, if the person tests positive for drugs or if they refuse to test, they have to be tested again and test negative in order to come back to work. So they call this a return to work program. And once the person is returned to work at that point after previously testing positive, they will receive at least 6 observed tests within 12 months, though this can be extended to 4 years. It's interesting, the regulations didn't really expand on when it would be extended to 4 years, but I suspect it would be something like if there was a negative test, of course, or if a positive test, and if they're repeatedly failing these drug tests, or if they have a history of repeatedly failing drug tests. This is sort of an interesting statistic. So only about 1/4 of drivers who are required to undergo a return to work program do successfully complete it and do in fact return to work. So the question sort of becomes, what has been the impact of these testing requirements on the trucking industry? According to the Federal Motor Carrier Safety Administration, more than 40,000 commercially licensed truck drivers failed federally mandated drug screens for marijuana in 2022. So to give you an idea of the prevalence of the problem, we talked at the last presentation about the fact that there were fewer than 200,000 truck drivers employed in 2022. So if you're trying to do the quick math there, that's over 20%. And more than 100,000 drivers have tested positive for past exposure to marijuana since 2020, in addition to about 60,000 more drivers who tested positive for other substances. There are some marijuana advocacy groups who are arguing that the nature of the tests is to blame for the prevalence of the positive testing. So specifically, inert THC, which has no psychoactive component, remains in the urine for weeks or months after exposure and is therefore not indicative of addiction, abuse, or recency of use. These groups further blame these tests for the interruption of supply chain and inventory shortages, of course, because it takes more of these drivers off the road when they test positive for drugs. And the marijuana advocacy groups do argue for the use of performance testing technology, which is, I think, just a fancy way of saying the field sobriety tests that you often see police officers do when they catch somebody in the field that they think is under the influence. Although alternatively, a saliva test has been proposed to the Department of Transportation, which these groups do acknowledge is a step in the right direction. Additional legal changes have included legislation in California which prohibits employers from terminating workers solely on the basis of a positive drug test for the presence of THC metabolites. So this sort of harkens to the fact that marijuana is obviously still not legal on the federal level, but it is on the state level in California. So I think that's California's attempt to sort of reconcile the fact that it is legal in California and not federally. Next slide, please. Health conditions incidental to being a long-haul truck driver, of course, include a higher likelihood of obesity and smoking, which can lead to heart attack, stroke, diabetes, high blood pressure, and other issues. So keeping in mind that while a driver may be more likely to be obese and or smoke, that does not make the condition itself industrial. So to the extent that it was in fact obesity or smoking which contributed to a person's condition, this is not necessarily going to be work-related. I have seen applicants' attorneys argue, particularly in police officer cases, that the nature of their work makes it more difficult for them to engage in healthy eating habits, thereby predisposing them to obesity. I have seen mixed results in litigating this particular argument, and with respect to police officers specifically, they do have presumptions which are intended to cover those types of issues, which obviously truck drivers do not have those same presumptions. But I would still maintain with respect to truck drivers, if you have an issue with obesity, smoking, any other kind of pre-existing issue, which may still be prevalent in truck drivers, it's still not industrial on its face. It may be aggravated industrially, but the condition itself is not necessarily industrial. Next slide. With respect to why truckers are more susceptible to these health issues, we know that they don't have as many healthy choices for meals. They don't have access to exercise facilities. Their access to care is more limited, and the nature of their work makes it more difficult for them to maintain healthy relationships. Unfortunately, these are just issues that are incidental to the nature of the work. So that's something that can contribute to that. Next slide. Other conditions to which truckers may be subject include less than ideal sleeping conditions and long periods of sitting interspersed with greater physical activity with loading and unloading their cargo. They may also be subject to vibration from the engine and the road, resulting in fatigue, insomnia, decreased oxygenation, and back pain. Some of these factors can, of course, be mitigated depending on how the trucks are outfitted and what types of retrofits can be made to make the truck more comfortable. And this also emphasizes why keeping up on routine maintenance is really important, as we discussed during our last webinar. And of course, truckers are subject to a physical examination for the renewal of their commercial licenses. So this can sort of help to monitor the extent to which they may be suffering from these conditions between employers or throughout their employment with one entity. Okay, next slide. Last year in California, 277 people were killed and 3,939 people were hurt in crashes involving a large truck or bus. Nearly 3% of the 8,696 accidents involving a truck or bus had at least one fatality. So obviously your chances of being in a fatal accident increase significantly if it involves a truck or a bus, which of course makes sense, unfortunately. Next slide. So the companies that had the most reported accidents include Werner Enterprises, Swift Transportation, and US Express. All right, next slide. Neck, back, and upper extremity injuries can be caused by loading and unloading trucks and boxes, containers, bins, or garbage cans. These injuries can also occur when maintenance is being performed or equipment is being used to do the loading and unloading. Most of these injuries are the result of overexertion during lifting. So knowing that these are the types of claims that you commonly see with trucking employers can help us anticipate and defend against these types of injuries. Prophylactically, I have had larger employers employ programs such as an on-site physical therapist who provide services to the employees and their families. This serves the purpose of helping an injured worker who may have experienced an injury to recover more quickly, as well as it documents the injuries and the complaints that arose in association with the injuries. It sort of gets you that first level of documented evidence of exactly what their complaints were, the extent of their complaints, the impact of the complaints on their activities of daily living. As we know, once they see an attorney, those things can really snowball. So having them documented at the outset of the claim can really be helpful and important. Having these types of programs, of course, also generates goodwill toward the employer, and it could make an injured worker less likely to litigate a workplace injury or less likely to seek time off work. The Canadian Medical Association Journal put out an interesting study in the early 2000s, which examined the expectation of injured workers versus their actual recovery time from workplace injuries. Basically, what they found was that a physician's knowledge of an injured worker's expectations for their recovery helped them to give a more certain prognosis. So in other words, where the injured worker is on the same page with the doctor as to what they can expect their recovery from an injury to be, it can help the physician give a better idea of like when the person would be permanent stationary or how complete their recovery may be, especially associated with the person's expectations. And I know we see this, I see this quite a bit, I expect everybody does, that you'll get a medical report where it says that the person did not improve as expected, or that the person's complaints got worse. And I think a lot of the time that has to do with the fact that the injured worker is expecting a return to a pre-injury level of functioning, which unfortunately for a lot of people, that's just not realistic. And I think that they tend to hold up their treatment or seek additional treatment because they're seeking a result that's not going to happen. So I think that better coordination between the physicians and the applicants would potentially help with these expectations, may help the person to getting a final medical report a little bit more quickly. Definitely something that you could ask during an applicant's deposition, a doctor's deposition, if they had that conversation with the injured worker about where they should end up being as a result of that injury. And I think we'll particularly see it with surgeries as well. A lot of these injured workers expect that the surgery will bring them back to their pre-injury function. And again, I don't think that that's realistic, unfortunately, in a lot of cases. The study in the Canadian Medical Journal also found that expectations of a slower recovery or greater uncertainty of those expectations were associated with longer periods off work and obviously increased receipt of wage loss benefits. So again, that makes sense. The person is off work longer because they're seeking additional treatment because they think that they're supposed to get better than they are. And whether or not they are actually improving, they're still seeking that pre-injury function. In the cases I have had where I've had notes from an on-site physical therapist, I have noticed that injured workers seem to be more open about prior injuries, where they're just in there talking informally with this therapist, getting some help. They really feel like the employer is helping them and on their side. And the injured workers do tend to be more cooperative when you are early on in the process like that and you have somebody helping them proactively. So I will say that offering the services of an on-site therapist for a non-work related injury could help get some goodwill from the injured worker as well. But you do have to consider, obviously, there are potential liability implications. For example, if physical therapy doesn't go so well, if that could end up causing a work-related injury. So there are pros and cons to that kind of a system, but with larger employers, it seems to have worked well if you could have a good program in place for that. We also know that having a strong return to work program can help speed an injured worker's recovery. So the ability to accommodate work restrictions can help limit exposure, obviously for wage loss benefits from a work injury, although of course subject to the risk of additional injury. If you have an applicant who's back with work restrictions, they of course are also back being exposed and potentially to a further work-related injury. I did mention that truckers have to undergo periodic physical examinations to renew their commercial licenses, so that can help provide us with a medical baseline. Though in my experience, they do tend to underreport any medical issues which are not otherwise documented, because they do not want to risk their licenses not being renewed. This is something that could potentially affect their credibility with a judge or a medical examiner, but I do think it's a relatable sentiment. We can all understand why you would not report every ache and pain when it could jeopardize your ability to get a job. So while those periodic physicals are available and should be available, they may not always be super helpful. So when you're assessing whether a musculoskeletal diagnosis is industrial, it's important to understand what kinds of mechanisms can cause whatever diagnosis you're dealing with. If it is something that is thought to be solely the result of genetic factors, so a condition that is normally just the result of something non-industrial, you'll of course want to question any industrial causation that's attributed to that particular diagnosis. I have seen doctors try to explain industrial aggravation of a condition that is otherwise solely caused non-industrially. And again, you want to be certain of the exact actual mechanism that the person was exposed to, which allegedly aggravated that non-industrial condition. So in deposing a doctor, you'll want to ask about things like medical literature that can support the conclusion that whatever job duties the injured worker had can actually mechanically aggravate an otherwise non-industrial condition. So keep in mind that when you do ask a doctor for medical literature, the doctor does have to provide it. So you want to stay on top of the doctor producing that information if you're requesting it, and make sure that it actually says what they are saying it says. If you are unsure as to whether the medical gibberish the doctor gives you is what is reflected in the medical literature that you are provided, it may be helpful to consult with an in-house medical provider, such as a physician guide who works for your TPA, or even a utilization review physician or a nurse case manager, to make sure that you're on the right track with reconciling that medical literature with what the doctor told you during the deposition or in the medical reports. One strategy that I use is to question doctors very specifically regarding an applicant's job duties, and to question them regarding exactly which job duties caused or aggravated each specific diagnosis. And this doesn't just apply to musculoskeletal injuries, but it would be with respect to any injury. You want to know specifically what was it, particularly in the course of a continuous trauma claim. What was it specifically that this applicant was doing at work which caused the diagnosis that you've reached, and more importantly, the industrial diagnosis that you've reached? And in these types of situations, it is helpful, of course, to have a job description handy, as I have found that very often, unfortunately, whether intentional or not, injured workers may not accurately convey work responsibilities, or they'll do so in a way that is vague, which leads the doctor to believe that the work is more intense than it is. For example, I have a case where an injured worker told me that he had to lift 80 pounds for work, and through a line of very specific questioning, I found out that they were either lifting that weight with a hand cart or other equipment, or that they were prohibited by the employer from lifting that weight without the assistance of a coworker. So in those types of situations, lifting 80 pounds is actually now lifting 40 or 50 pounds. These factors can swing a doctor's opinion on causation, and can really affect the credibility of the injured worker. Specifically with respect to psychiatric cases, I did litigate a psychiatric case recently, and the AMA guides do actually suggest that the physician, i.e. a PQME or a PTP, consider motivating factors for the person's recovery from a psychiatric injury. And I took that one step further with respect to how they're representing their symptoms, the impacts on their daily living, to a PQME. So knowing what the motivation of the injured worker is with what they're telling the PQME is important, and it's important for that PQME to understand that motivation, whether it's a financial incentive, whether it's staying off work longer. They need to understand that when determining whether they think the applicant is credible. And that doesn't just go to factors of malingering, which usually include things like symptom magnification. Those are, observable signs with respect to their physical condition, but really knowing their actual motivation with respect to whether or not they're just being truthful. So we did discuss earlier, for example, that vibration from an engine and the road can cause back injuries. So for example, in this case, if a doctor tries to extend this to something like a knee injury, you'd want to ask them during a cross-examination what the causal connection would be between exposure to vibration and whatever the diagnosed knee injury is. Knowing what a person's likely pre-injury baseline is, of course, also very important to determining causation and apportionment of any impairment. The gold standard, of course, and the ideal situation to proving apportionment is having studies that were done just before the injury or employment, and then immediately after the injury or employment. But not only is it fairly unusual to have that kind of a situation, I have gotten some pushback from doctors who may be attempting to advocate for the applicants, who will say things like, well, the quality of the diagnostics from the prior injury or the prior employment are not sufficient for comparison, or it was an incorrect view, or it was done with or without contrast, which they didn't want. Recently, I've run into an issue where they want to see the actual films, which are very, very, very difficult to get. So you do run into issues with that, even if you have the ideal diagnostics in place. So with absent pristine studies on both sides of a work-related injury, keeping in mind some things from the AMA guides may help provide some guidance as to the normal aging process, for example, for back injuries. Page 383 of the AMA guides says that 30% of individuals will have herniated discs without radiculopathy by the age of 40, and 40% of individuals will have aging changes after the age of 35, with nearly 100% of individuals showing aging changes by the age of 50. So that sort of makes the testimony I got recently from a chiropractor that my 75-year-old applicant has no non-industrial apportionment for a degenerative back condition seem fairly incredible. Conversely, though, you have to consider that spondylolysis is normally only found in 7% of adults, while spondylolisthesis is normally found in 3% of adults. So diagnosis of these on a work-related basis would seem a little more likely. Next slide. Okay. Sorry, I just saw a question. Some difficulty hearing me. Okay. So the types of injuries that a person could sustain as a truck driver include falling from elevations. Vehicles obviously are fairly elevated, the trucks falling on stairs, falling into openings. This could occur during loading and unloading, making deliveries on upper floors. And most commonly, the injuries that result from falling from elevations include knee and back sprains falling out of the vehicle. Next slide. So of course, you also have work that is done on the same level, which can also result in falls. And it can be such as when lifting the latch on the back of the truck or putting on chains, loading and unloading, of course, obviously, again, back and knee sprains are the most common type of injury caused by these types of falls. So with respect to these types of injuries, falls specifically, the best way to mitigate your exposure for these claims is to work to prevent them. Providing workers with a safe environment is always best practice, of course, though that is just the first step. The best safety system in the world is useless if your workers don't know how to use it. Routine safety meetings can remind an injured worker of the safety protocols that are in place, and they can help protect the employer from a claim for serious and willful benefits. Conversely, they can also even allow the employer to file a serious and willful claim against an applicant in order to reduce benefits if it turns out that the person had been trained repeatedly in a particular safety protocol and failed to follow it. I will say that I have had injured workers admit to me that they go to these safety meetings and they almost always have no recollection of what was discussed in those meetings. And when I hear this, I just picture everyone standing around a warehouse with their eyes glazing over while someone talks at them. So in situations where a safety demonstration, like with the use of actual equipment, is practicable, I think that that would probably be more effective. Next slide. So you can also have injuries by being struck by or against objects. People hitting hitched trailers, containers, things falling out of the trucks. You know, obviously items can shift while they're driving. If you open the back, something could potentially fall out. Hopefully those types of things could be prevented by securing cargo and avoiding things falling. The most common types of injury from objects falling are back sprains and strains. Next slide. Of course, vehicle-related injuries are also an occupational hazard for a truck driver. More than half of driver fatalities are caused by vehicle-related injuries. I would actually suspect that most of them would be caused by vehicles, but workers can also be hurt when they lose control of a vehicle. Unfortunately, I've seen too many cases where somebody is pinned between, you know, maybe a forklift or a pallet or whatever. Most of the time, those claims I see are not fatalities, but they certainly can be. And this goes back to my point, of course, that work injuries like this should best be avoided at all costs if possible and can mostly be prevented with robust safety training. Accidents, of course, do happen, and addressing any injuries which occur right away with compassion and managing their expectations, I think, can help reduce exposure in the long term for the extent of the injury. Next slide. So truck drivers who perform different types of work, of course, face different types of injury. You know, whether you're a residential truck driver, obviously the nature of your work is going to be very different from a long haul truck driver. You're doing more stopping, unloading, carrying boxes, things like that. Driving industrial trucks, you know, you're probably lifting and loading and unloading bigger items than obviously a residential package delivery person might otherwise be. Okay. And I just want to talk a little bit about some updates on the trucking world. It's always important to keep up with, things that are happening, just to kind of be aware of what other employers are going through, and anecdotally to try to help create safety programs and things like that. So as of September of 2023, truck tonnage was down 4.1% year over year, which is the biggest drop in almost 3 years. This is compared, though, with September of 2022, which was the previous high point. Tonnage in 2023 had been on the rise since April of 2023, at which point it was sort of at a dip, and then it dropped off, obviously, in September. The consensus seems to be that this is indicative of turbulence in the trucking industry. And the hope is that as we enter the holidays, consumer spending will stay strong, and this would be reflected in the increase in tonnage. Though it is anticipated that there will be overall slowing of the economy as we enter 2024. We do know, of course, that the economic roller coaster that we've been on for the last few years has been impacting the trucking industry. I meant to mention this in our Part 1 webinar, but in August of this year, the company Yellow, formerly known as YRC Worldwide, was the third largest small freight trucking company, and they declared bankruptcy 3 years after receiving a $700 million federal bailout. And their bankruptcy came in the midst of union contract negotiations. This closure resulted in the loss of 30,000 trucking jobs, and it's not clear what's going to become of the bailout money, which was a loan and had bought the federal government a 30% stake in the company. Interestingly, Estes, which is the fourth largest small freight trucking company, is buying up many of Yellow's assets in the midst of the bankruptcy proceedings, and they may be seeking to expand their market share. Although, interestingly, they are unfortunately in the process of recovering from a cyber attack which hit them in early October. So that's what I have. Nas, I think that was my last slide. If there are any questions, I'm certainly happy to answer them, as I know Nasir would be as well. So you can go ahead and type them into that question panel.
Yeah, thank you, Kim. Can everyone hear me okay? Kim, you can hear me now? Right,
Yes.
We're back.
Yep.
Great job.
Okay, I don't see any questions at this point. So if you guys do have any questions, Nasir and Kimberly's contact information is right there on your screen, so you can email them if you have questions for them. As I mentioned earlier, certificates for MCLE and CE will be emailed this afternoon. I will include a link to the PowerPoint as well. Our next live webinar is going to be on November 21st with John Kamen for our annual legislative update. I wanted to mention again, if you missed part 1 of this trucking series in August, it was back in August, the video is on our training page and you can watch that anytime. For B&B attorneys, it's on our MCLE internal page. We really do appreciate you all joining us, and we hope that you enjoy the rest of your week. Thank you all so much. Take care, everybody.
Thank you, everyone.
Bye, everybody.
Thank you.